Gillian Merchant is a discrimination lawyer with Thompson's Solicitors. Gillian, listen, thank you so much for coming on air, and we'll try and help people in this position. But before we do that, is this quite common? Are you finding folk coming to you saying, look, I'm being told to come to work and I don't want to, and I don't need to?
I think most employers have been sensible about it, and where they can have allowed workers to work from home. I mean, I think there are some occupations, where it's clear that the work can't be done from home, like frontline NHS workers, care workers, shop workers, clearly can't be done from home. I think there are other kind of primarily office-based jobs, like my own, which can very easily be done at home. And then I think there's kind of, as always, there's that number of workers in the middle who it can be a bit unclear whether or not they should or shouldn't be in work. And I think undoubtedly there is still a feeling amongst some employers, as was foreshadowed in your piece, that people are not as productive at home, or people aren't doing anything at home. And I think probably one of the best things that will come out of the pandemic for industrial relations will be that the vast majority of workers have shown that actually that's not true, and actually productivity has just been as good at home as it is in the office. However, I think there are some employers who probably still hold what I would deem as old-fashioned views in terms of working from home.
Well, we don't have the data in front of us at the moment to make a judgment on that. But in terms of somebody has a complaint, they're being told to come into the office and they don't think they're essential. In fact, they've looked at some guidelines and they figure they've got a case. What recourse do you have? How do you progress? How do you progress your feelings here?
I mean, that's the difficulty in all of this. I mean, the Scottish Government's working from home guidance is that. It's guidance. It is not a legal requirement. And the difficulty for employees is they have very, very limited legal rights in terms of what action they can take against their employer in these circumstances. Essentially, what they do have is what we would call a Section 44 claim, which would be under the Employment Rights Act, which essentially means that if an individual considers that they're working in a circumstance that's of danger, that's serious and imminent danger, then they can essentially not come into work or leave work and not suffer a detriment because of that. But obviously that's quite a high level. And even in the case study that was voiced by your producer, I think it would be really interesting in that to know what actually the reasoning of the employer was for why those workers need to be in the office.
Well, in terms of whistleblowing, I think you mentioned the word there. Is there no agency you can go to, aside from, say, a legal firm, and say, look, I think this firm, my firm in particular, is at odds with guidance?
I mean, I think the easiest way to collectively raise issues is always to join a trade union and act collectively in that manner. If you think your workplace is unsafe, then obviously you've got the legal protections that I've outlined, and also the health and safety executive who deal with health and safety at work cases. However, in terms of actual, not having to attend work in a circumstance where they could easily do work at home, there's not any immediate redress for those kind of circumstances, and I think that is a big problem in this whole situation, is that workers are being forced to go to work when their work could be done at home. Just
very briefly, is it clear, do you think?
No.
Really? Okay. All right, Gillian, thank you very much indeed. Gillian Merchant, a discrimination lawyer with Thompson's Solicitors.